Bonjour, everyone, and welcome. I'm just going to give a few seconds to let people time to get into the webinar. I'll take just a few seconds. Perfect. So as the numbers are ramping up and everyone is logging in, so I want to take a few seconds to introduce myself. So my name is MJ. I'm a Director of Business Development at Alexa Translations. I want to thank you all for joining us today for the webinar on understanding the impact of Bill 96 and how to prepare your business. We're just running a few minutes after the hour, and we will start a discussion, and we have a lot of interesting content to share with you today. So throughout the webinar, feel free to use the Q&A section to ask the panelists any questions, and we will get to them during the discussions. We also want to say a special thank you to our event partner, ADB Insight, who are also actually hosting the Canadian Legal Innovation Forum next week in Toronto. This being said, it is my great pleasure to introduce Gary Kalassi, CEO of Alexa Translation, who will be presenting the panelists that we have the honor of having with us today. Thank you so much and enjoy.
Thank you, MJ, and thank you everyone for joining us today. I know it's been a hot topic. There's been a lot of discussion around it. And part of the intention for today was to take away a bit of the mystique around it, try to shed some light as to how it works, what is some of the background around it, but also how to turn it into a bit of an opportunity. So although some of this is being mandated by legislation, from a business perspective, there's always opportunity that comes behind it. And how can we interpret that? What are things we can do? What are initiatives that have worked in the past that we can really run with? And it is a truly all-star panel, people that have been hands-on with this, even in terms of providing advice to the government, suggestions as to what could be done to actually make this better overall. So I will start by introducing first our moderator today. And although he's our moderator in a somewhat atypical fashion, Kevin will speak a fair bit himself as well. But Kevin Asiri, a debt finance and lending law lawyer in Montreal, has been with a few national firms and a regional firm, and has his own practice right now as a boutique firm in debt finance and lending law. Perfectly bilingual, and well, actually trilingual, I'd like to say, and minus any other languages I may be missing. I feel like that's consistent with our entire panel here today. So they understand translation well beyond the immediate English and French. And Kevin, I know as we get started, you probably speak a bit more to your own context, but I'm keeping them very high level right now so that we can keep it focused. And Tanya Da Silva. Tanya is a partner at DLA Piper out of the Montreal office. Tanya is actually an employment and litigation lawyer. So whereas what you'd get from Kevin is a lot of the perspective from debt and banking and finance, Tanya will provide that perspective from employment and litigation. And certainly, last but not least, we have André de Morives from CIBC. He's senior legal counsel at CIBC and has been in charge of this project on behalf of CIBC, but also in charge of Quebec matters on behalf of CIBC. So truly, like I said, all-star panel and a group that is a lot of fun as well. So in the process, it's not going to be just an informative session, but also a session that we all learn a lot from. So Kevin, I'll let you take it from here without further ado, now that we're all here.
Thank you so much. Thanks, Gary. And Andre, I love the suits, by the way. So thanks, everyone. Thank you, first of all, to Alexa Translation for organizing this webinar. It's an important topic, and we'll get to that in a moment. I also want to thank, of course, all the attendees. There are many of you, understand, hundreds apparently from across Canada, some from overseas. Who knew that language laws of Quebec would be so interesting? And they frankly are. I'm actually fascinated by the various topics that are behind the law. And I'm actually looking forward to what Andre and Tanya are going to say. But before they share with you the more substantive side of things, I want to bring you back in time, bring you to your high school history classes, if you would. Let's go to Paris, France. on Champs-Élysées. And whether those of you who've been at Champs-Élysées, look down Place de la Concorde, which at the time where I'm about to take you was called the Place de la Révolution. Louis XVI was beheaded by the guillotine on January 21st, 1793. And I bet you no one expected to be talking about the poor man's grisly death. And I apologize if I'm jolting you by bringing that topic up. But the sense of time is important because on that very day, 230 years ago, more or less, but exactly on January 21st, 1793, across the ocean on this side of the world, at what was then known the Parliament of Lower Canada, which today is Quebec, our parliamentarians were having their first official debate about languages. And they decided, to their noble credit, that the Speaker of the House would be bilingual, that the civil law of what was then New France, which became Lower Canada, which became Quebec, those civil laws would be drafted and legislated in French, but criminal law would be in English, as a reflection of the hybrid system of law, civil and common law, and the influence of the Napoleonic Code, the founding population of New France, and the British parliamentary system after the 7-Year War, when Canada became what is more or less known today, with the two systems of law being merged. It's important to think about that time because when last time I was in the National Assembly, and you'll appreciate this, in Quebec City, where our parliament is. So those of you who've been to Ottawa, we have the exact same thing, beautiful building in Quebec City, in what is called le Salon Bleu, where our deputies, those people we vote for, the people we ask to make our laws, to reform our laws, to amend and debate the issues of the day, for the last 100 years, there is this massive, massive painting, which you can see from the viewing gallery, and you'll appreciate what I'm about to bring to your attention is that painting depicts not the demise of Louis XVI, but rather that very first parliamentary debate in Lower Canada about languages, the famous language debate. So there is a meaningful symbolism about the interaction of French and English in how our lawmakers handle themselves, how they advocate for their constituents. And what is important to realize is that the language debate has been going on for many, 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 many long years, and I suspect it will continue. And this webinar is not about politics, certainly not about identity politics, regardless of where you are in the political spectrum, whether you're in Quebec, whether you're in Montreal or outside of Montreal, outside of Quebec, outside of the country. This will be for a fireside chat when everyone comes to my place, or we go to Andre's or Tanya's, and we can discuss these on or off the record as to what our personal views are. But what's important to realize is something that I think all the lawyers attending will particularly appreciate. I'll never forget the first day of law school. The Dean of Law comes to the assembly hall where all these law students, including myself, were sitting. And he said something to the effect that in a working democracy, in legitimate democracies, laws are there to be updated and reformed to reflect the then needs and the mores, the values of the very society they seek to serve. And I don't think of a better time to realize that that principle actually holds true. Why do I say this? The last survey shows that I think apparently 95% of Quebecers who are Francophone are in favor of a major change to our language laws. That rate is significantly lower or noticeably lower for Anglophones or non-Francophones, but I don't think many people would disagree that protecting a form of protection of language laws is important for any community. And certainly I'll share my view is that I think I'm all for it, regardless of the merits, the scope, how much these changes may or be complex. I'm not suggesting that I'm in agreement with all of them, but the point is the change is coming. It's going to happen sooner than we think. And it's very important for everyone to be ready for it. And that's the reason why this webinar was set up, to prep everyone. And I want to also say that we won't have time to cover many of the topics that should be discussed. This will be simply a overview. We'll do some deep dive. I want to encourage everyone to use the chat box. We want to keep this as fluid as a conversation as possible, answer your questions in real time. And before I ask Andre and Tanya to speak of their topics, which are predominantly, Andre will speak about how businesses, business contracts, commercial contracts, pleadings, relationship with clients, how that is going to be affected by Bill 96. Tanya will speak to predominantly the relationship between employers and employees. Of course, there are many other subtopics, and hopefully we'll keep some time at the end to discuss and share with you our views of the best practices, how to optimize and how to be prepared for the changes. Again, it's going to be a packed hour. But before I ask Andre to start, I want you to also keep in mind 3 interesting fundamental pillars, which in my view, the government has used to prop up this new law. Knowing that the current provincial government has an absolute majority, regardless of whether it was voted in 2018 to amend the laws. That's besides the point. The point is they have voting majority. This Bill 96 in one shape or another will become law very soon, but they are couching the bill, I think, on 3 pillars, one of which is already on the books in Bill 101, which is what the current French protection laws are known from 45 years ago. But they now make it a fundamental right for people who reside in Quebec to live and work in French. That's, I think, important to realize. There's going to be some, and that affects all kinds of spheres of life in terms of dealing with the state, business, schooling, and newly arrived immigrants, how municipalities get funded. And the list is very, very long. And we're going to only discuss a few of those topics, really. But that's definitely one pillar. And the second 2 pillars are, I always have a smirk on my face when I discuss it, and I'll share with you because it's very interesting. And that's more of a political discourse of the meaning of these 2 pillars. The second pillar, in my view, is that the Quebec government is amending the Canadian Constitution. It does in Bill 96. Here we have a province who actually, last time I checked, hasn't even signed on to the Constitution as it was adopted in 1982. Quebec was not at the table, unfortunately. And yet here it is saying that we are amending the Constitution of Canada. And the politicians in Ottawa have acquiesced, actually, for all kinds of reasons. And that's besides the point as to what their motivation would be. But I find that quite interesting with some bit of irony. And the third and final pillar, in my view, of this foundation of this legal framework is the use of the notwithstanding clause. And for those of you who do not know what the notwithstanding clause is, it is the ability of any province or territory of Canada to adopt a law which may be perceived as breaching the fundamental rights protected by the Charter of Rights and Freedom of Canada. And this is quite an interesting strategy by the provincial government of Quebec, in that it sort of protect itself, ideally, and despite the challenges that I suspect are going to go before the courts, it protects itself against too much success, because it is possibly very legitimate, that use of the notwithstanding clause, regardless of the precedents and so on. So keeping all of this in mind, and one final sort of more view of where we are, especially for those joining us from outside of Quebec, it's just the current color and texture of why updating this law is perceived as very important. And frankly, it is important. Think of the fact, and I'll use a very quick personal anecdote. In 1962, my in-laws moved from France to Montreal. They didn't speak English. So my mother-in-law once in a while recalls how she was never able to get service in French when she shopped at Eaton's, which was a massive, large Canada-wide department store, which no longer exists. Or fast forward to maybe 3-4 years ago, where the fact that vendors or service people in Montreal stores would welcome clients by saying bonjour, hi, as opposed to just bonjour. The media went to town on it. The politicians got involved and they said, why do we use bonjour, hi? And more recently, about 4 months ago or so, the head of Air Canada made a speech in English only. And he went out of his way to say to the media how he has successfully resided and worked in Montreal, I think for over 12 or 14 years, without the use of workable French. And then currently, this is ongoing now, CN Rail, which like Air Canada is has its head office in Quebec, has an AGM of its shareholders in a few weeks. And apparently they have a slate of directors up for re-election or election, and they are not francophones, or they're not from Quebec. So it is a very sensitive topic. And I find that this is also something to understand as to why the Parliament of Quebec has debated this, and finally using this majority in the context and the will of the people that they serve, they are now adopting this law, which will now affect everyone, particularly businesses that want to carry on business here or have clients in Quebec. If they want to be in compliance, there's a lot of work ahead. And so please, those of you who bring this back to your management, to your peers, to your colleagues who don't have the benefit of the context, I encourage you to share why that is, so that they are better prepared to take on the amendments successfully. And as Gary said, I see, and if we have time, we can discuss this, I see a sea of opportunity here to be very successful and thrive. It has never been a better time to be in business in Quebec. We have the lowest unemployment on record, I believe. So do not let Bill 96 create any fear. There is no reason for that. I think everything's going to be fine. And the success is for those who are going to be agile enough. All of this to say, I want to give a warm welcome as well. I want to thank Andre and Tanya to join me and share with you what they're about to do. So without further ado, Andre, why don't you take it away? Thanks so much.
Well said, Kevin. Thanks for the intro. Apologies for arriving late. You'd think after 2 years of the pandemic, I'd be a little more technologically savvy, but my kids obviously are much more advanced than I am. So we'll jump into the portion of Bill 96 that I was going to discuss today with you, which is the commercial contractual aspect. And I think Bill 96 has brought about amendments to several pieces of legislation, namely the Charter of the French Language, which Kevin referred to as Bill 101. And several other pieces of legislation, notably the Consumer Protection Act. And the reason why I'm referring to the Consumer Protection Act first is because of the contractual implications. So once Bill 96 comes into force, we'll have a year in order to ensure that all standard form contracts, which in Quebec we refer to as contracts of adhesion, will have to be provided first in French to all consumers. And only after they've received a French version and upon request by the client or the consumer, can an English version be provided. So this is a significant game changer from how business is currently conducted today in Quebec. Typically, if a francophone shows up to do a deal, they'll provide the contract in French, and if an anglophone shows up to do the deal, they'll provide the contract in English. Going forward, we will have to provide all contracts of adhesion in French first. So it's a significant change, and the government is providing with a 12-month transitionary period from the time that the Bill 96 goes into force. It should be also noted that all contracts and written correspondence with the civil administration will need to be in French. Civil administration is a very broad term. It includes obviously the government, but it includes many legal entities that are subsidized by the Quebec government. So that would include universities, it would include public transportation, the liquor store, which is the SAQ in Quebec, municipalities, and the list goes on. So, it'll be interesting to see, because you could even have a municipality that is principally Anglophone. It'll be interesting to see how they deal with that. There are some exceptions, which I'm not going to get into, unfortunately, today, because we just don't have the time. However, I do want to list a couple exceptions, which are probably of interest to most people on this call. And the following exceptions basically exist definitely on a B2B basis, but not necessarily on a B2C, a business to consumer basis. And that's because of the conflicting amendments in the Charter of French Language and the Consumer Protection Act. So under the Consumer Protection Act, it's clear that all contracts with a consumer need to be in French first. I do know that there are some groups out there that are still in contact with the government regarding that discrepancy or that potential interpretation. So hopefully we'll have more news on that discrepancy in the next few weeks. But in the meantime, at least on a business-to-business basis, all loan contracts can be provided in English if that's the request of the client. You don't have to provide a French version first. Financial instruments and contracts whose object is the management of financial risks. So we could think of derivatives, for example, currency exchange, interest rate exchange agreements, options, futures, all those types of financial instruments can be provided in English first if that is the request of the client. A contract entered into with a person or enterprise that's carrying on the activities of a clearinghouse. Similarly for exchange platforms for derivatives or securities. And any insurance policy where there's no equivalent in French and it comes from outside of Quebec, or it's not widespreadly used in Quebec. So those are kind of the 5 main exceptions from the contracts of adhesion perspective, where you could provide an English version of the document first if that's the client's request. And this goes back to what Kevin was saying, though. There are some other changes or amendments that require going forward that you need to ensure that for every contract you have, form of contract that you have in Quebec, there exists a French version. You can no longer, if you're currently doing it, have an English only version of some type of form of contract. It's basically, you need to, the law clearly states that you now going forward always need to have a French version, and the French version needs to have the same terms and conditions, or must be as equally favorable as the English version or a version in another language. The consequence for non-compliance to not providing a French version to a client, unless you follow one of those exceptions, is that the contract of adhesion could be rendered null and void as if it never existed. So that's obviously very important, and hence why you want to make sure that you're in compliance with these new regulations within a year's time of Bill 96 coming into force. Some other couple of amendments is you can't charge the client for translation costs. So this means it's got to be assumed by the business. And a friendly reminder that the most is that external clauses, and some of the lawyers on this call will probably know this, but the external clauses, they have to be drawn up in French unless the contract was drawn up in another language. So basically, you can't have an external clause in another language other than French unless all corresponding documents are obviously in that other language. And the last thing that I was going to talk about, since time's ticking away, is under the commercial contract side, is if you take collateral, as of 3 months, once this Bill 96 comes into force, all the registration of collateral security in Quebec must be exclusively in French. So that's whether it's with the land registry or with the RDPRM, which is for movables. We will only be able to file these registrations going forward in French. And it's the public policy behind this, is really behind all of this, and I think Kevin noted it, is they want to ensure that anything that is in the public sphere, in the public domain, is available to francophones, and that francophones can understand what's there. So since the security registries are public domain, they want to ensure that anyone can understand what's been filed.
So Andre, actually, you and I haven't discussed this, but you work at the bank. I truly appreciate this. So for those of you from outside of Quebec, we're talking about the equivalent like a PPSA filing or mortgage filing, a public register. And as Andre mentioned, this is because I guess the government doesn't want the third party searching to have a working knowledge of English, or as if you're a mortgage lender outside of Quebec or in the US, you will want your documents to be in English as the law allows now. And I think that will continue to be the case, certainly B2B, business to business. However, and I'm wondering if the CIBC, for instance, has taken a policy position on whether the bank as a lender, for instance, or if you have any form of major agreements where you want the other side's lawyers to give an opinion about the validity of the documents or the fact that they've been properly registered, would you now start expecting and asking for translation accuracy opinions?
It's a good question, Kevin, and we are, like all the F5s, are still looking at these aspects. But I would definitely say that it's in more complicated cases. For example, a building, for example, a skyscraper in downtown Montreal, for example, where there's lending going on and there's tons of servitudes. It's quite probable that, yeah, we would ask for a type of translation accuracy opinion to ensure that everything's been translated properly, and that there's nothing missing from the filing, because obviously you're financing based on the underlying collateral, and so you want to ensure that the collateral has been published appropriately with the respective, in this case, the land registry.
Right. So my editorial comment on that is, when we have hundreds of millions of dollars at stake, or much less, the point is the lender want to make sure that somebody's backstopping that risk, and that includes law firms. So my advice to all the lawyers on the call and the translators on the call is to get ready to provide proper French, accurate French, legal French translation of the English collateral description. And those could be a few lines, could be pages and pages long. And I think that's an essential something people haven't required, especially at we realize that the secondary market, especially if things are going in the US, if a law firm starts having fun with legal opinions and they put assumptions or qualifications, like we provide no opinion to the extent of the accuracy or the scope of the translation of the collateral as registered in such registry office or at the equivalent of PPSA or the Personal Property Security Act level, I think there's going to be significant pushback. So I'm of the view that opinions are and should be required, but that will be the role of the bilingual lawyers in Quebec who will have to vet, and the translations who help them out, the translators, sorry, who will help them out in getting that description in real time translated before it is registered. So please continue, Andre, and then we'll pass on to Tanya.
I think really three other things that I wanted to touch base quickly is all client communications basically going forward. You need to ensure that there is a French version that exists. So basically Bill 96 amends the Charter of French Language by ensuring that all documentation, and they actually broaden it to include websites or any client-facing systems or technologies that are available to the public, must now be available in French. So, if currently you have a website that's English only, for example, that's not going to fly going forward. It'll be interesting to see how the French language regulatory body deals with those businesses that potentially have no physical establishment in Quebec, but are outside of Quebec, and that potentially might not have a French version of the website. Kevin, I don't know if you have thoughts on that, but that's definitely something that
I'd like to hear Tanya's views on that. And in fact, here's a question for you both that Sonia Montpetit, and thank you, Sonia, for joining us. Maybe either of you can take this. And this, Andre, deals with the relationship with the state. With documents supporting a registration with a governmental agency, such as Registre des Lobbyistes. So if you're a lobbying group, you have to register with the government. Does that have to be in French now? And
yeah, I'm to be honest with you, I haven't looked at the aspect of the lobbyist registration. So my assumption is they're going to still allow people to register whether they're an Anglophone or a Francophone, because there are some exceptions. I don't know if lobbying falls under that exception. I don't know if Tanya, if you've looked at it from that angle or not.
I haven't, no.
So thank you, Andre. And Tanya, why don't you now start telling us about your topic that, of course, you're an expert on, predominantly employment law, and how the employers deal with their employees is going to be crucial going forward under Bill 96. Why don't we start with that? And after a few minutes, we should ideally discuss some best practices. So go ahead, please.
Sure. So I'll touch first on the employment agreements, because the obligations that Andre was referring to spill over into employer obligations as well. So currently the law requires that employment contracts be provided in French unless the parties have otherwise agreed in writing. So the current practice typically for a lot of employers who are from outside of Quebec but operating in Quebec is to have an English version of the contract that includes what we call the French language clause. And this applies to any document that the employee is asked to sign and agree to, like confidentiality agreements, restrictive covenants, IP protection agreements. We'll have a clause in there that says the parties have expressly agreed that this document and all related documents be drafted in the English language only. Typically, that's enough unless somebody requests the document in French specifically, in which case it's translated and provided, and then they have the French version going forward if it's needed. But as Andre said, now what's required is that the French version be provided at the outset. It has to be provided first, and then only if the employee requests it in another language can it be provided in English. So what does that mean for employers? It means you should be looking at your employment agreements, checking if they need to be updated, and then having them translated so that when this comes into force, you'll have that French version available to provide to any new candidates that you have in Quebec that you're interested in hiring. Aside from that, I can then speak about expanded obligations related generally to communications that employers have with their employees in French. It's already set out in the current law that workers have a right to carry on their activities in French. That's a general right that's set out just at the beginning of the Charter of the French language. The new legislation says specifically that the employer has now an obligation to ensure that the worker's right to carry on their activities in French is respected, so that there's an additional obligation there on the employer. So what does that mean practically speaking? Let's say, for example, employers only provide a certain training to their employees in the English language. It's provided out of their California office by somebody who's speaking about, let's say, anti-harassment. And it's only available in the English language. Everybody has to follow it. It's mandatory. Where that may have been okay under the current legislation, now the employer has an active obligation to make sure that the worker in Quebec can carry out their activities in French. So when you're talking about mandatory training that is presented orally, there's no written communications involved necessarily. Now you have to look at whether you have to translate and provide that same training to your employees in Quebec in the French language.
So Tanya, that's significant because I'm thinking of cost of doing business, right? So, and you know what, I'll put it out there. Some businesses may say, you know what, too expensive, too difficult, I'm out of here. I will leave Quebec. But for those who want, and in my opinion, should continue, in fact, increase their footprint in Quebec. So does that mean that they need to now hire someone? And I guess with the pandemic, they can hire that person anywhere in the world, to be honest. But does that actually mean that they need to just have a, in real time, or record a French version of the presentation or have a French transcript? Or do they actually need to have someone on site in Quebec that provides all of that in French? How do you see that?
The content has to be accessible and able to be provided to the employee in French as well, so that they can carry on their activities in Quebec in French. So if you're telling them you can't conduct harassment in the workplace, they have to understand that in the language of their choice in French, in many cases in Quebec. So the content has to be there, which is not necessarily the same for documents, where there are certain requirements for documents where it has to be accessible in this under the same terms as the English version. So it's not specified that training, for example, presented orally has to be exactly the same, English and French. However, there is that requirement with respect to certain documents. So the new legislation specifies that employment application forms, all documents relating to conditions of employment, so your incentive plans, your benefits plans, your RRSP plans, etc., and all training documents produced for employees will have to be available in French on terms that are at least as favorable as the versions that exist in any other language. So let's say you have your English version on your intranet, your French version has to also be on your intranet. Your employee in Quebec shouldn't have to go look for the French version of the document where it's easily accessible in the other language.
And Tanya, this is regardless of the number of employees you have?
Yes,
in
so
Quebec?
correct. These are obligations that are applicable to all employers, and I'll get to francization obligations later on, which I'll touch on quickly, where you have to do a more involved process to potentially provide even more things in French to your employees. But this obligation that I'm speaking of is for everyone. Generally, under the current legislation, this refers to any communications in writing at large to employees. So your policy manuals, things that are provided to everybody from the company. The new legislation now also specifies that these communications to individuals need to also be in French. So that raises a very interesting practical aspect that we don't know how it will be handled in practice, because let's say the CEO of a company wants to send an email to all. That would be currently captured by the translation requirements of the Charter of the French language. It would have to have a French and English version to go to everybody who's in Quebec, or just a French version. But if that CEO wants to communicate with an individual only in Quebec, acting as his capacity of representative of the company, does that have to be in French only? And if that CEO doesn't speak French because they're in another country, how does that apply practically? So that's an interesting point that's raised by the new legislation that we'll have to wait and see how it is put in practice. But for the time being, what does not seem to be captured by the new legislation is one-on-one employee communications. So those don't have to be translated. But when somebody's acting in their capacity as a representative of the company, unless the employee specifically says, I'd like to receive your communications in another language, it appears that that person will have to send those communications in French.
So Tanya, do you expect the regulatory body to provide some guidelines on this? I suspect they're not going to wait for this to be litigated.
Right, and the OQLF, or the Office de la Langue Française, which I'll just call the Office, they're the agency that currently oversees application of the charter. They do put out many guides, even currently, to help assist, for example, with social media, how to post on social media and in compliance with the charter. They have many guidelines in that respect. So we do expect to see that, and they generally are open to us asking questions and to employers, working with employers to make them compliant. I'll jump quickly just because I see the time flying to another new requirement, which is the new hiring process. With respect to job offers, the law currently requires that employers publish advertisements in a daily newspaper the employer who publishes an advertisement for a job in a newspaper in a language other than French has to also publish it in a French version. Under the new legislation, employers who intend to post a job offering must do so in French. And if the advertisement is published in another language, has to ensure that it uses the same means of transmission and reaches the same public target of a proportionally comparable size. So you have to assess the tools you're using to put your job offers out there and make sure they're reaching comparable English and French target audiences. You also will have to change the hiring process to assess whether you really need your employees to speak English for the job that you are posting. So the new legislation says that employers have to take reasonable means to justify that knowledge of another language is required as a hiring criterion. This means that every employer will have to be able to demonstrate that it has assessed the actual language needs associated with the duties of the job that they're posting, ensure that the language knowledge already required from the staff that they currently have is not sufficient to perform those duties, and that it has restricted to the maximum extent the number of positions involving duties that require the knowledge of a language other than French.
Tanya, if I were an employer, actually, I'm starting to get worried now. And I'm not kidding, because this is rocking their world, and rightly so. And I suspect they will adapt. Those who want to adapt, who want to put the resources, will adapt, and I'm convinced they will thrive. I'm a fundamental believer of that. But first of all, is there going to be a transition period for this?
Yes, yes, it's the 1-year transition period for the same that André mentioned in order to become compliant. Some of them do not have that 1-year period. For example, the communications that already have to be provided to employees in French, there's no transition period for that, but this assessment, you will have time to comply and to make sure that you meet the requirements of what it is to do this assessment exercise. And what employers should keep to be mindful of with respect to this exercise is they need to keep records of their hiring practices and how they've met this obligation. Which leads me to my next point, which is that employees have a new recourse under Bill 96. So tied to those hiring obligations for employers is this new recourse. So an employee who feels that or believes that they've been a victim of reprisals or unlawfully required to have specific knowledge of a language other than French will be able to file a complaint for a prohibited practice with the Quebec Labor Standards Board. They can do that within 45 days of the occurrence of an incident. So at least the time period for them to file the claim is not very long. It's 45 days, after which it's precluded. And if it's not settled, then this claim goes for adjudication to the labor tribunal.
That's a novel, that's absolutely a new thing, correct?
Yes, it's completely new. Before, what employees could do was call the office and complain that their employer was not meeting the requirements, and then the office would open an investigation. They would contact the employer to find out what they do provide to their employees in French, and if they did not provide communications in French, require them to do so. But this is a personal recourse that the employee can take to seek reparations under the before the labor tribunal.
So
Yeah, I just want to interject there, Kevin. It's very similar for consumers. Also, in the past, consumers could make a complaint regarding lack of use of French or an infringement of the Charter of French Language by filing a complaint with l'Office, or the language regulatory body. But going forward, they're going to actually have access to one of 6 tribunals, including the Human Rights Tribunal. And so, that actually enlarges the scope of both legal and reputational risk, obviously, because when things were dealt with l'Office, it was all behind the scenes, and you were able to have fluid conversations and so forth. Now, if someone files a complaint with one of the 6 tribunals, it's like going to court. So it's a very different way of resolving the issue.
On my comment on that, actually, and thanks, Andre, is before the average consumer sort of clues in of these newly acquired rights, it's going to be a while. It's going to be past the transition period, unless there's some local advocates who want to, push people to complain. But I personally, I'm not too worried about that in terms of, I wouldn't panic if I were an outside merchant, an out of Quebec merchant who's not ready for that. But certainly it is definitely a meaningful, we have to be aware of that. And again, as I mentioned earlier, it's a vast topic. We will definitely not have time to cover all of them. But the questions have come in, and I'll start with this one for Tanya. It's a question from Landa, if I hope you're pronouncing your name right. What about the case of French employees who have an English or Anglophone manager in Ontario? In what language should they be speaking, and how will that performance review go about? Can you talk about the current state of affairs and how the law would change that, if at all?
Sure. So the current state of affairs is that they can communicate in the language of their choice. There's no obligation around verbal communications currently, other than the employee's general right to conduct their activities in French. And there's no requirement that they even correspond one-on-one in French. With the new legislation, it's not certain whether that one-on-one correspondence can be in English if the employee wants it to be in French, because there is a specific requirement now that the communication from the company to individual employee be in French unless otherwise requested by the employee. So because there is a managerial relationship there, it's not clear. And what I would recommend is that you ask the employee, can we conduct this in English, so that they can respond, yes, we can conduct this in English, so that you have that confirmation from the employee that it can proceed in English. The performance review, if it is in writing, will have to be in French.
So that in practice, though, does that mean that there could be some activist employees who they may be perfectly bilingual, they say, no, I want to be reviewed in French because that's my fundamental right in Quebec? Do you think that's going to happen?
It could happen, and it's something that we're seeing more and more of, even in our communications on behalf of employers with government agencies. I've had mediators tell me that I've asked mediators to proceed with mediations in front of the Labor Commission in English or with a bilingual mediator, and lately have been told more than before, no, this will proceed in French because the mediator that's assigned to your file is Francophone. So I do think that is a possibility.
And that's a topic for a webinar all to itself. Here's another question from Hélène Marcotte. Would you know what the consequences will be for a business that posts some information in English only websites, information that is intended for the general public? This goes to the issue of maybe Andre, you can take that one, of how the law is being changed to, they refer to catalogs or forums and so on, and how now it's on any medium, any support, which I suppose includes social media and websites. So what
Yeah.
happens if I'm have a website with general info accessible by Quebec residents, but it's not in French or bilingual?
So, I mean, that exactly falls under that topic of ensuring that all public information is available in French at the same terms and conditions or as favorable as in another language. It's a mirror to what Tanya was just speaking about on the employee side. So the consequences are obviously you could have those clients filing complaints with one of those 6 tribunals, namely the Human Rights Tribunal. So that's a legal and a reputational risk. You obviously have a reputational risk because it's to your advantage to ensure that your clients are able to understand and read the publicly made available documents in both French and English if you want to ensure that you're targeting both Anglophones and Francophones in Quebec. So the consequences, and then depending on the decision, the office or the language regulator could also file a complaint with the tribunal. And actually, the office now has certain rights where they can actually provide a financial penalty against legal entities that don't respect the new requirements. I think off the top of my head, the lowest amount for a legal entity is $20,000. But it could go as high up to all the revenue or profit that that legal entity has made based on that infringement if the office goes to court and requests that as a judgment by a judge.
Yeah,
I see.
and I could just add to that, the current state of affairs with respect to websites is that it's akin to a brochure or a catalog and had to be translated. However, where the company didn't have an establishment in Quebec, the office generally didn't enforce or could not enforce because there were only penal recourses available that can't really be enforced extraterritorially. But now with these additional recourses that are available, it opens up the possibility of those websites being subject to the requirements.
And that's going to be a very good topic for litigation, no doubt. Here's another question.
Sorry, I'm just jumping in for housekeeping because I'm looking at the time at 1:57, and I wanted to leave we had spoken with our panelists, and we said, knowing that this topic would be dense, we may need them to stay on for a bit longer after the hour. But knowing that some of you may have to drop off momentarily, please let us know. Part of what we consider is, does this become serious? Because there is so much content, and even the legislation, it's not in its final form just yet. There's still little tweaks that are being done. So continuing this would make a lot of sense. We'd love to hear that from you, though, and if there are particular topics of more interest, so we could facilitate more of this. But all that to say that we'll continue a bit longer because we had asked the panelists that in advance. I just wanted to, in case some of you had to drop off, to throw that in there momentarily. Thanks, Kevin.
Thank you, Gab. I kept the whole afternoon. Are you kidding? This is
Perfect. We're all set.
Bless the heart of the lawmakers. So here's Tanya. There's a question for you. In the example that Tanya presented about the CEO emailing a Quebec employee, is the CEO allowed to send the email in French first with the English at the bottom, or it must only include the French? In other words, can I, as a CEO from California, send you a bilingual email?
Yes, the answer is yes. There's no requirement with respect to the order either. As long as both versions are in the email, there's no
Right.
problem with sending something bilingual.
That's the doctrine of come on. It makes perfect sense. If the terms of a job offer are given in French, and then upon request given in English, and the English terms are more favorable to the employee, can the employee avail itself of the more favorable English terms? That's, by the way, that's on the translators, incidentally, if there is a discrepancy. So, but what do you think, what happens if there is this a broken telephone between the two versions? Then what happens?
Yes, so that's a good question, because that is more of a civil code of Quebec question than a French language question, where, you know, if there is if it's an employee, the public order will allow the employee to avail itself of the more favorable terms, because there is a certain level of protection for the employee under our civil law.
Right.
So yes, that's something that is to be mindful of and very careful of when you're looking at your employment agreement translations.
I would even say that, Kevin, that applies now also on the consumer side, because of the changes made by Bill 96. If a consumer enters into an agreement and for whatever reason there's an advantage in the other version, the other language version, the client can avail themselves of that advantage.
Mm-hmm.
And that's the doctrine. It's not a doctrine, but really common in layman terms means that the vulnerable party, the employee or the consumer, has the upper hand. They cannot be caught off guard. So the contract will be interpreted in their favor, not the other way around. Tanya, here's another email. If a job termination email is sent in English to a Quebec employee, in other words, that implies, I suppose, that the email termination is, and I hope it's going to be preceded with a phone call, please. Let's assume the email is in English only. Is that a valid termination?
So that's a good question, because the email, I think, yes, would still be valid. But if you're wanting them to sign a release and you're presenting only the release, that is an agreement, a contract of adhesion, and can be struck with invalidity as the penalty for having provided it in English only first to the employees. So if you are proceeding with the termination of an employee, French should always be used to make sure that you're not faced with that situation, especially if you want an enforceable release in an employment context.
Anyway, after this call, I think I'm going to retrain in employment law. Never mind. There's another question from Ata. Hi, Ata. We know each other. How are you doing? This, I guess, would be for Andre, if you want to take this one. Some firms publish material from employees on their websites, which can be in English or French. Do all such publications need to be provided in French as well?
So, and Tanya will correct me if I'm wrong, but if the publication is necessary for them to do their work, then the answer would be yes. But if it's not something that they need in order to accomplish their work, then it does not need to be in French. I hope I said that right, Tanya.
Mm-hmm. Yeah.
So we're past the hour. I wanted to maybe open up, and again, if questions want to come in, if people want to stay, we have a few more minutes. But Andre and Tanya, what are your top 3 advices for businesses out there who hear this and they're going to scratch their head? What do we do now? Mm-hmm. How do you think they should position themselves? How should they tool themselves? What kind of resources they're going to need? What are the steps that you recommend? Tanya, why don't you go first?
Sure. So I think I didn't even touch on the subject of francization.
But
we
won't have time. No.
But that's something that employers need to keep top of mind if they have around 25 employees, because that's something that is going to be new for them. Right now, the threshold is 50 employees to meet or to be required to do francization or look at the general use of French in your company as a whole. And there's a whole exercise tied to that. So reach out to your legal counsel or to a consultant or someone who can help you with francization obligations if you are around the 25 employee mark in Quebec, because that's something that will become necessary for you. Identify, as I said, the documents that must be provided to employees in French and begin translating them as soon as possible so that you will be able to provide them if you aren't already, because some of these are already required. And otherwise, start working on that assessment exercise for your hiring process and what that looks like, so that when you want to hire new candidates in Quebec, you will be prepared.
And thank you, Tanya. Andre, as you're talking, here's one question that's also apropos regarding certified translations. Can you maybe just start with that, certifying translations when used in Quebec, and then share your other recommendations?
Yeah, one of the things I didn't get to talk about were legal pleadings. So within 3 months of the bill becoming in force, all legal pleadings filed at the courthouses have to be either in French or have a certified translation, so not an uncertified translation. So I definitely see an uptick in certified translations, Graham. So that's definitely something to consider. What I was going to say is, I mean, you know, we are under the impression that this bill is going to come into effect likely in the month of June, potentially June 24th, which, as you know, is a symbolic holiday here in Quebec. That would mean that it would be enforced. We're all coming up with a provincial election in October. So I think the current majority government, as you pointed out, Kevin, would like to have this in place before that election. So if you think about it, if it goes in force June 24th, that means certified translations or legal pleadings will need to be certified by the end of September, basically starting at the end of September on a going forward basis. So I think we're going to see translation outfits quite busy. They probably already are quite busy. You know, we at CIBC have been looking at this bill since it came out back in May. And so, I mean, one of the things I would recommend people doing is, if depending on where they are, is to have legal, internal or external counsel review the bill, and then have discussions, internal discussions with the various stakeholders. And when I'm talking stakeholders, obviously HR, compliance, management, technology, those would be the key ones. And the reason why I mention all those is obviously Tanya as well talked about all the potentially HR issues that might come about, and you want to make sure that you've put into place the proper remediation to ensure you don't find yourself in a sticky situation. Technology, because a lot of companies now either have in-house technology or external technology, but a lot of that technology sometimes takes a while to make changes. This can take several weeks, can take several months, even more so when you're using a third-party service provider to start contemplating the potential changes that have to take place. So these are all things that we've been working on over the past year, and highly recommend that everyone else do so, considering that I think this bill is coming much sooner than we had potentially originally forecasted.
Yeah. To that, I would just add that for some of my clients, there has been delay in this, resulting from which cost center we attribute this to. We don't know who should be paying for, you know, the translation, the changes, everything that needs to be done and implemented, because it affects everything, especially in a francization context. So start determining that early on, because it is going to be one of the first things that you have to address when you start implementing is who is in charge, like Andre said, and where do the funds come from? What cost center is going to be responsible for these?
It's going to require some leadership here, so it doesn't become a hot potato. For the translators on the call, go to your boss's offices and ask for a raise. You're going to.
And Kevin, there were certainly many translators, especially a lot of internal translation departments that joined. So I think you'll see a lot of demands for raises.
Well, don't mention my name. There's one last question, and we can maybe perhaps conclude, unless there are last-minute chats, or you can upload a question. There was a question from Germain Marcotte. Thank you, Germain, asking whether there is actually a summary of Bill 96. Well, how much time do you got? There is, unfortunately, to my knowledge, the three panelists, or Gary, we don't have a summary to hand out to you because it is a vast topic. Depends on what area of law you want a summary of. But many law firms, if you Google Bill 96, and if you're at it, why don't you Google the painting and the Salon Bleu? That would be an interesting issue. I love that story. You will see that many firms in Quebec have either generic summaries or industry specific, but the version of the law that's about to be adopted in a few weeks is not crystallized yet. Since last fall, they spent about 175 hours in parliamentary committee going through more than 200 articles of law. they have nothing better to do, but it's an important exercise, and it was debated at length. And there were many amendments that are not, certainly not available in English yet. They will, of course, be translated. The laws have to be still bilingual here, and they will continue to do so. So there are some, so for instance, I know for a fact, some of the things that Andre spoke of are not yet available in English. For instance, in financing or in certain other aspects of the law. The point of the matter is, please stand by. The legal market will cater to the demands. There will be a lot of summaries out there. Be careful about, though, anyone who says don't worry about it or plays down the importance. I think this law will have teeth. And I want to conclude by saying, please don't forget, from my perspective anyway, this is not a reason to leave Quebec, absolutely not. The province is definitely going places, and it makes a lot of sense to preserve French, the quality of the French. And my last request is, please come and visit Montreal. The pandemic is not over, or is it? I don't know, but it's a summer. It's a great city. Come to Quebec City, go see that painting in person, and think of this webinar. So why don't I pass it on to Gary, and I want to thank again also Andre and Tanya for all their involvement. Take it away, Gary.
No, thank you, Kayvan, and Tanya, Andre, thank you, and MJ for putting it together. I think we've had our answer here, and Sebastien, we appreciate you putting the link with the document. It's even that is 100 pages, so it tells you how much goes into this. But the reality is, I think we have our answer that there should be a follow-up to this session, and probably split it up into more consumable pieces, and we'll continue with this series following the final form of the law. And I had some tips to share which were sort of best practice on how to approach it. Happy to share with any of you offline so that we don't hold you up further. But thank you all for making the time. It just shows how important it is, and what an opportunity this is also to see this as an opportunity to engage with your customer base as well as with your employees better in French.
Thank you again, Gary. Thanks, everyone. All the best.
Thank you, everyone, for joining.
Bonne journée.
Bonne journée à tout le monde.
Au revoir.